My name is Severina McGill and I teach at Jindal Global Law School. This module is for the Upasana UGC. This module looks at maintenance and custody as part of national legislative frameworks that concern women and children's rights. By the end of this module, the reader should be able to be familiar with and identify various laws regarding maintenance and custody within India, have a brief knowledge of the impact of judicial decisions on maintenance and alimony applications, and be familiar with various factors which govern matters regarding the rights of the child principle. Students should also have awareness of how these laws intersect with family law. Maintenance and custody are two primary issues arising out of a matrimonial dispute. Maintenance under the classical law generally refers to the husband's obligation to financially support the wife during marriage and also on divorce or separation. Provisions for maintenance arise out of the personal laws as well as the Code of Criminal Procedure from 1973. Such provisions have typically aimed to secure the finances of the wife and to ensure the same standard of living to her. It also regards maintenance for children that she has custody over and for which she had when she was married. Recently, courts have started denying maintenance to women who have the capacity to earn independently and are not financially dependent upon their husbands. Challenges have also recently come to courts with men requesting maintenance if the wife was the primary income earner. This module will examine legal rights to maintenance and custody from a women's rights perspective under various personal laws and how these affect her right to life and non-discrimination. The right of maintenance is recognised as a statutory right that serves a social purpose to prevent women from becoming destitute and impoverished following the breakdown of a marriage. Recognising women's socio-economic inferiority within society, access to maintenance is recognised as a means to secure to all women an adequate means to livelihood. This directly relates to the Constitution provision of 39, especially when read with 15(3). Maintenance may be awarded to women as a special provision. Its status as a statutory right has also led courts to state that a wife cannot bind herself by agreement with her husband and give up her right to maintenance. It was held that the parties therefore cannot, by an agreement between themselves, agree to oust the jurisdiction of the court which otherwise Parliament has conferred power to. In the case of Purnananda Banerjee versus Swapna Banerjee and another, in a proceeding for divorce and maintenance filed by the wife, the husband challenged the constitutional validity of Section 36 of the Special Marriage Act from 1954. He claimed the Act did not provide the husband with the option of claiming maintenance, unlike the Hindu Marriage Act from 1956. The Court of Calcutta upheld the constitutional validity of Section 36 in view of the constitutional provision of 15(3), which 15(3) states that nothing in this article shall prevent the state from making any special provision for women and children. Such interpretations by courts demonstrate the level of importance given to maintenance as a right for women and its intent to ensure women are not unfairly and unequally left vulnerable after separation and divorce. In the case of Bhuvan Mohan Singh versus Meena and others, the Supreme Court held that the husband cannot take subterfuges to deprive her of the benefit of living with dignity. This section will examine rights to maintenance as under secular, Hindu, Muslim, Christian and Parsi laws. Section 125 of the CRPC, the Code of Criminal Procedure, states that if any person having sufficient means refuses or neglects to maintain his wife or legitimate child, then such a party may apply to the magistrate who may order a monthly allowance for maintenance of the child or the wife. In the case of Chanmunia versus Virendra Kumar, the Supreme Court held that women in live-in relationships can also claim maintenance under Section 125 of the CRPC. It was stated by the Supreme Court in this case that, thus, in those cases where a man who lived with a woman for a long time, and even though they may have not undergone legal necessities of a valid marriage, should be made liable to pay the maintenance to the woman if he deserts her. The objective behind granting maintenance in such cases is that the woman should not be led to vagrancy and destitution. In the case of Chaturburj versus Sitabai, it was held that the test is whether the wife is in a position to maintain herself in the way she was used to living in the place of her husband. The expression unable to maintain herself does not mean that the wife must be absolutely destitute before she can apply for maintenance under Section 125 of the CRPC. The court in this case also cited the case of Bhagwan versus Kamla Devi, where it was observed that the wife should be in a position to maintain a standard of living which is neither luxurious nor penurious, but which is consistent with the status of the family. The liability under Section 125 does not absolve on punishment for non-payment. It only absolves when the actual payment of maintenance is done. In the case of Ajit Kumar versus Shaima, it has been held that imprisonment does not and cannot absolve a petitioner of his liability to pay maintenance. Imprisonment is not a mode of satisfaction, but is only a mode of enforcement of liability. In another case decided by the Apex Court, it was held the liability can be satisfied only by making actual payment of the arrears. Sentencing to jail is the means for achieving the end of enforcing the order by recovering the amount of arrears. Section 24 of the Hindu Marriage Act from 1956, herein the HMA, deals with maintenance pendente lite, which means pending litigation. It states that on the application of the husband or the wife during any proceedings under the Hindu Marriage Act, where it appears to the court that the applicant has no independent income sufficient for her or his support including the cost of litigation, the court may order the respondent to pay the applicant such costs and expenses. Maintenance under Section 24 can be granted only when the proceedings are pending, and thus, when the case is disposed of, the maintenance under Section 24 also ends. An application of maintenance under Section 24 is not maintainable when the marriage is void. This may be problematic for women who are either unable to prove their married status or whose marriages may be declared void as a previous marriage had not been dissolved prior to their marriage, with or without their knowledge. It may therefore lead women who thought themselves to be married to be left financially vulnerable. Section 24 also includes considerations such as the applicant's own income and the income of the respondent. It has been held that maintenance awarded cannot be punitive. It should aid the applicant to live in a similar lifestyle that he or she enjoyed in the matrimonial home, and it should not expose the non-applicant to unjust contempt or other coercive proceedings. On the other hand, maintenance should not be so low as to make the order meaningless. An income affidavit thus has become an efficient tool to help the court in deciding the fair amount of maintenance to be granted. In the case of Puneet Kaur, a detailed format of the income affidavit was given and facts such as tax receipts, property ownership, school fees, fuel expenses, total income packages and day-to-day expenses had to be disclosed. In another case of V. Usha Rao versus MLN Rao, it was held that the term income sufficient for her support is not to be narrowly construed, and it cannot be held to mean bare subsistence. It means that the spouse should be in as much comfort as the other spouse, and to which she was habituated whilst they were living together. Maintenance for minor children can also be granted along with maintenance of the spouse under this section. Even though Section 24 does not explicitly refer to children, it has been held in the case of Damodharan versus Meena that the court can involve Section 24, which discusses custody proceedings, and grant maintenance if required. Section 25 deals with permanent alimony and maintenance. It states that any court on an application by the husband or the wife at the time of passing of a decree order, the respondent should pay to the applicant for her or his maintenance and support such gross sum or such monthly or periodical sum for a term not exceeding the life of the applicant. This section, although entitles both spouses the right of maintenance, most of the time is decided where it secures the right to the wife to secure support. Even if the decree is in favour of the husband, that does not restrain the court from passing an order of permanent alimony and maintenance in favour of the wife. While one can file an application for maintenance under Section 24 whilst the proceedings are pending, Section 25 can be used at the time of the decree under this Act or thereafter. In the case of Chand Dhawan versus J. Dhawan, it was held that when the main petition has been dismissed or withdrawn, permanent alimony is not payable under this section. While deciding an application under Section 25, the court has to take into consideration the income of both of the parties and even the conduct of the parties. The amount of alimony to be granted is the court's discretion, taking into account various factors such as ownership of property, lifestyle of the parties, day-to-day expenses, predictable changes in circumstances, and the capacity to earn. The Special Marriage Act from 1954 applies to persons who are married under the Act. Section 36 deals with maintenance pending proceedings and 37 deals with permanent alimony. Unlike the Hindu Marriage Act, a husband cannot claim maintenance under the Special Marriage Act. Section 18 of the Hindu Adoptions and Maintenance Act, herein HAMA from 1956, states that a Hindu wife, whether married before or after the commencement of the Act, shall be entitled to be maintained by her husband during her lifetime. This section reaffirms the Hindu ideology of maintaining your wife. While under the HMA, the laws treat both husband and wife equally to claim maintenance and alimony, the Hindu Adoptions and Maintenance Act specifically talks about the right of a Hindu wife to claim maintenance during her marriage from her husband. The liability of the father-in-law arises only on the death of the husband. Section 18(2) states that a Hindu wife shall be entitled to live separately from her husband without forfeiting her claim to maintenance. The case of Purama versus Siddhappa Jivappa upheld this, stating that mere agreement to live separately, unless there has been dissolution of marriage in law, cannot be a ground for refusal of maintenance. Maintenance includes everything that fulfills basic necessities such as food, clothing, residence, medical treatment, and education. The court also has the jurisdiction to provide for interim relief of maintenance under this section, and it does not depend on the challenge by the husband questioning the validity of the marriage. Such an interpretation by the court is very gender sensitive. It allows maintenance even when living separately. It doesn't force women to live in unhappy or abusive relationships, and nor does it subject women to have to get divorced if they do not wish to. It therefore upholds the privacy and the choice of the woman and her right to financial security whilst maintaining her dignity. Section 20 of the HAMA specifically deals with the right of maintenance for children and aged parents. It states that a Hindu is bound during his or her lifetime to maintain his or her legitimate or illegitimate children and his or her aged or infirm parents. The maintenance under this section can be claimed from the father or the mother. In the case of the state of Haryana versus Santra, it was held that there is no difference between a legitimate and an illegitimate child with respect to the question of maintenance. It was also stated in the same case that maintenance would obviously include provision for food, clothing, residence, education of the children, and medical attendance or treatment. The obligation to maintain, besides being statutory in nature, is also personal in the sense that it arises from the very existence of the relationship between the parent and the child. The obligation is absolute in terms and does not depend on the means of the father or of the mother. The court can make an interim order for relief of maintenance under Section 18 and 20 of the Hindu Adoptions and Maintenance Act. Section 23 deals with the amount of maintenance to be ordered and states that courts have the discretion to determine whether any, and if so what, maintenance shall be awarded. The Act states that in determining the amount to be awarded, the court should consider the position and status of the parties, the reasonable wants of the claimants, and if the claimant is living separately, whether the claimant is justified in doing so, the value of the claimant's property and the earnings, and the number of persons entitled to maintenance under the Act. In stating down such clear guidelines which also consider the claimant's assets and income, the HAMA clearly aims to strike a balance between meeting the monetary needs of the claimant with existing provisions and the respondent's capacity to pay. Under Muslim law, a Muslim wife can claim maintenance under the Code of Criminal Procedure 1973, the Shariat, and the Muslim Women Protection of Rights Upon Divorce Act from 1986. Under personal law, a wife is entitled to maintenance as long as the wife is faithful to the husband, does not refuse to cohabit with the husband, and obeys his reasonable orders. After divorce, a Muslim woman is entitled to maintenance, and the claim should be settled during the period of iddat. In the infamous Shah case, the Supreme Court held that Section 125 of the CRPC was applicable to all without prejudice to their religion. This created a large reaction from male Muslim religious leaders, and that it was interference with their personal laws. The Muslim Women Protection of Rights Upon Divorce Act was then passed, providing a codified set of rules to govern maintenance for Muslim women, and effectively limiting their ability to access the secular CRPC and to seek equality with other women in India. The move was criticised as being an act passed to appease the powerful voices of the angry religious leaders at the cost of securing women's dignity as a rights holder free from discrimination on the basis of sex. The constitutional validity of the Muslim Women Protection of Rights on Divorce Act was challenged in the case of Daniel Latifi versus the Union of India. The petitioners stated that it was against the ruling in the Shah case. The court held that the payment of maintenance as implied by a bare reading of the provisions of maintenance under the Act was not limited to the period of iddat. Further, it was held that a divorced woman is entitled to a fair and reasonable provision for her future being made by her former husband, which must include maintenance for a period extending beyond the iddat period. Section 39 of the Parsi Marriage and Divorce Act deals with maintenance pending litigation, and Section 40 deals with permanent alimony. Under these sections, both husband and wife are entitled to claim maintenance or permanent alimony. The court takes into account various factors such as the income of the applicant and the respondent and the conduct of the parties. The Indian Divorce Act from 1869 governs marriage, divorce and maintenance for Christians within India. Section 36 addresses alimony pending litigation. Only the wife is entitled to claim relief under this section. In the case of Joy Kuti Matthew versus Valsamma Kuruvilla, it was held that even if the wife has an independent source of income, it does not disentitle the wife from claiming alimony under the section. Dismissal of application under 125 of the CRPC is also not a ground for disentitlement of the wife from claiming alimony under the section. Section 37 of the Indian Divorce Act deals with permanent alimony. Custody refers to the physical care and control of a minor. It involves routine tasks associated with bringing up a child and day-to-day decisions which affect the child's life. Decisions could include which school the child should attend, dietary habits, extracurricular activities, and medical treatments. In matrimonial disputes, the child is the worst sufferer due to no fault of theirs. Therefore, courts follow the policy of the welfare of the child or the best interest of the child to decide custody disputes. The best interest of the child supersedes personal laws as well. The best interest of the child has to be decided taking into account various factors and several complex socio-ethical issues. Some of the factors which are taken into account are the minor child's wishes, the finances of the parents, the conduct of the parents, for example, whether the parent acted in a cruel manner or if the parent suffers from any mental or physical ailment. The following section will examine custody laws under different personal laws. Section 26 of the Hindu Marriage Act states that in any proceeding under this Act, the court may, from time to time, pass such interim orders and make such provisions in the decree as it may deem just and proper with respect to the custody, maintenance, and education of minor children. Section 6 of the Hindu Minorities and Guardianship Act states that the natural guardian of a Hindu minor, a boy under the age of 18, or an unmarried woman or girl, is the father, and after him, the mother. This proviso to Section 6 provides that in cases where the minor has not yet completed the age of 5 years, the custody of the child is with the mother. In cases where the child is illegitimate, the guardian is the mother and after her, the father. In the case of Geeta Hariharan versus the Reserve Bank of India, the validity of Section 6A of the Hindu Minorities and Guardianship Act was challenged. The idea was that it was violative of Articles 14 and 15 of the Constitution of India. The petitioner claimed that she should be an equal guardian to her child and should not come after the father's legal right of guardianship. The court held the word after shall have to be given a meaning which should subserve the need of the situation, vis-à-vis the welfare of the minor, and have due regard to the fact of law that courts endeavour to retain the legislation rather than declaring it to be void. The court stated it felt it was expedient to record that the word after does not necessarily mean after the death of the father. On the contrary, it depicts an intent so as to ascribe the meaning, such as in the absence of the father, be it temporary or otherwise, or the total apathy of the father towards the child, or even the inability of the father to reason by ailment or otherwise. And it is only in the event of such a meaning being ascribed to the word after, as used in Section 6, that the event would be in accordance with the intent of the legislation, vis-à-vis the welfare of the child. Therefore, although the court expanded the meaning of the word after the father to include situations where the father was alive but absent, it did not put on par the rights of the mother as a legal guardian with the father. Her rights to non-discrimination on the basis of sex, recognition of her as an equal parent, and her dignity to be a mother without secondary status were therefore denied by the court. In many judicial decisions, the welfare or best interest of the child is the primary and paramount consideration. In the case of Rajesh Gupta versus Ram Gopal Agarwal and others, a habeas corpus petition was filed by the father for the custody of his minor daughter. The child was living with her mother and her grandparents. The father alleged that the mother was suffering from schizophrenia. The court held that in an application seeking a writ of habeas corpus for the custody of a minor child, the principal consideration for the court is to ascertain whether the custody of the child can be said to be lawful or illegal, and whether the welfare of the child requires that the present custody should be changed and the child should be left in the care and custody of somebody else. The medical reports relied on did not show any such mental ailment as alleged by the father. It was also observed that the father, being a Supreme Court lawyer and hence very busy with his professional work, was highly unlikely to be able to stay with the child for long periods of time. The court therefore decided that the best interest of the child was for her to stay with her mother and grandparents, who were seen to be well educated and financially sound. In the case of Gaurav Nagpal versus Sumedha Nagpal, it was held that in the cases of custody of a minor child, the paramount consideration is the welfare of the child and not the rights of the parents under different statutes. In another case decided by the Supreme Court, the court held it is not a negative test whether or not the father is unfit or disqualified to have custody, but a positive test that must be considered regarding in whose custody would the welfare of the minor be most provided for. The court was therefore told that it should exercise the power to grant or refuse custody of the minor in favour of the father, mother, or any other guardian based on the best interest of the child. Under Muslim personal law, the father is considered to be the natural guardian of the child. Under Shia law, a mother is entitled to the custody of a minor son till the son is 2 years of age, and the custody of a minor daughter until she is 7 years of age. Under Sunni law, a mother is entitled to the custody of the son till he is 7 years old, and the custody of a minor daughter until she attains the age of puberty. In the case of Zara Bibi versus Abdul Razak, it was held that the right of the mother to custody of minor children till a certain age operates even after divorce. The courts have time and time again emphasized on the principle of the best interest of the child. In the case of Muhammad Khalid versus Zinat Parveen, when the father under the Muslim personal law was claiming the custody of the children, the Allahabad High Court held, though the father as natural guardian may have a prima facie case to minor's custody, this may be negatived if infant's welfare lies in keeping him in his mother's custody. The children cannot be treated as chattel or property. their welfare has to be considered more on humanitarian grounds and looking into the overall welfare of the child. In a recent case by the Supreme Court of India in Atta Hussain versus Saeed Siraj Ahmed and others, children were residing with their maternal grandparents after the mother's death, and the father initiated a custody proceeding. It was held by the apex court that although the father is the natural guardian according to the Muslim law, the court could not overlook the preferences of the minor children and the interests of them. The court found it was in the interest of the children that the custody should not be disturbed, and the father should then be allowed visitation rights. Sections 41 to 43 of the Indian Divorce Act also addresses the custody rights of children given to Christians. Even under the proceedings under the Indian Divorce Act, the primary consideration in deciding a case under the Act is the welfare of the minor child. In the case of Jacob versus Jacob, it was observed that children are not mere playthings for their parents. The absolute rights of parents over their destinies and lives of their children has, in modern changes and conditions, yielded to the consideration of their welfare as human beings. In the case of Duncan versus Duncan, it was held that the person to whom the custody is granted can be directed to not remove the child from the court's jurisdiction. Such orders help to ensure that both parents have access to their children. Under Section 49 of the Parsi Law of Marriage and Divorce Act from 1936, a court may make provisions with respect to the custody, maintenance and education of the children under the age of 18 years. In the case of 30 Hoshi Dolikuka versus H.S. Dolikuka, the mother was refused custody of her minor daughter by the High Court. This was because she was a working woman. The mother alleged that the father had poisoned the mind of the girl against her. The Supreme Court on Appeal stated that the employment of a parent should not be a primary condition in denying custody, and the High Court had erred in this. Custody was then granted to the mother and the father was given visitation rights. Courts have consistently ruled in favour of the presumed welfare of the child over personal law provisions. This demonstrates a desire to implement legal provisions with a consistent welfare of the child interest. As there has been no significant backlash from faith-based groups, it has been easier to create uniformity between different personal laws across the country, and thus helping to ensure equality between children from different faiths and the mother's role as a care provider. This module has introduced maintenance and custody provisions that exist in India in both secular and religious laws. The module has attempted to provide information on not just the key provisions that exist, but also how courts have interpreted them, particularly with reference to rights to dignity and equality for women. This module is now complete. Thank you.